right. Good day, folks. I am David Shwartz, an attorney here at Elder Law and Advocacy, and today I am talking to Madison Kovall, a tenant rights attorney, also here with Elder Law and Advocacy. And today we're going to be talking about a San Diego City ordinance that is changing how utility fees are regulated.
Correct. On July 15th, 2025, the San Diego City Council approved a residential tenant utility fee ordinance. And it obviously is to promote fairness, equality, transparency regarding how landlords charge utility fees to residential tenants. Went into effect on August 17th. Under the ordinance, a landlord may charge a tenant for city-provided utility services. So again, this is water, sewer, stormwater, trash, only up to the amount the landlord actually pays for that tenant's consumption. It doesn't cover utilities provided by private companies like SDG&E or Wi-Fi.
I'm going to ask, just to clarify for me and anybody listening, the limit is on what the landlord pays for consumption. So I'm thinking like convenience fees, credit card surcharges, things like that. Those would all be excluded. The landlord would have to eat those costs, can't pass that on to tenants as of August 15th.
No, I mean, so third-party companies can be used. And so if there's fees, they have to be itemized and can be provided to the tenant upon the tenant's request. So if the tenant is questioning how much they're being charged for consumption, they can request billing statements, invoices, and the landlord has 10 calendar days to provide those documents. And if they do not, then there's recourse available. The tenant could sue in court for, injunctive relief or monetary damages, et cetera, et cetera. So my understanding is that they cannot be charged for anything they're not consuming, but there could be pass-through fees as far as from third-party billing companies.
Gotcha.
And also, so there is a new notice requirement. So if a landlord wants to start charging you for utility fees, they have to give you a 30-day notice. And if they're already charging you, they're supposed to give you a 90-day notice about the ordinance.
Just to let you know that this ordinance exists, but it doesn't change how they have been doing business and will continue to.
Right. I mean, my understanding of the 90-day notice requirement is really just to provide you with information on your tenant rights.
Gotcha.
Yeah. And so I have a new case right now where the tenant is questioning the utility charges that he's receiving, and he did go ahead and request billing statements, and the owner has not provided them, and the 10-day window has passed.
Is this the kind of situation where the tenant wouldn't have direct access to those billing statements because the bills are not coming in the tenant's name?
Right. So the bills are just being added on to the monthly rent amount without a clear understanding of usage. And I guess that kind of begs the question, a little off the record, but so it doesn't apply if you're sub-metered. And I would imagine that could be because you would get your meter readings to show the start and the end every month. You would see your individual usage. And I think if you had a question about that or disputed that, you could bring that up as maybe there's, issues with the meter. I think a hot topic the last year and a half has been changes to California's security deposit law. So last summer, we saw that there were changes made to income limits. So previously, if you rented a unit and it was unfurnished, the landlord could charge up to 2 times the rent. If it was furnished, it could be up to 3 times the rent for just the deposit.
Gotcha.
And so last year that changed, and now the limit is 1 time rent for new leases or renewals after July 1, 2024. So basically, if you had already paid, over 1 month's rent before July 1st, 2024, the landlord isn't entitled. He doesn't have to return anything to you. But just moving forward, I guess with renting a new unit, you're limited to that 1 month rent. There is an exemption for small landlords, and a small landlord is defined as owning no more than 2 residential rental properties with a total of 4 or fewer units between them.
Okay. Not to pull you backwards,
Yeah.
but you mentioned the old limit was, I believe, double 1 month's rent for unfurnished, triple 1 month's rent for furnished units. With the new rule, it's furnished or unfurnished doesn't matter. It's just you can charge 1 month's rent. That's the security deposit maximum.
Correct. Yeah, unless it's exempt from that small landlord
Gotcha.
exemption. I will say, I guess, obviously this has been, this law was passed almost 18 months ago. I think what I see now is a lot of clients will call and possibly like the landlord has increased the security deposit with their rental increase or maybe just like an annual increase. And so a client will ask, is this legal? Can they increase my deposit? I've lived here for 5 years. And so the answer is yes, they can with proper notice. It's generally a 30-day notice. And they can increase it, again, up to that 1 month of rent unless an exemption applies. So I feel like that can be a financial burden for someone if they're already now having to figure out how to pay a rent increase at the same time. And so I find that it could be helpful to even just request a payment plan for the deposit if it is like a significant increase that you can't afford to like immediately pay.
That's a good idea.
Yeah. And so why I bring this up, fast forward to this year, we've seen new changes in security deposit law as well. And so California AB 2801 was introduced and went into effect starting July 1st, 2025. And it includes important changes to how landlords and managers must handle deposits and claims for damages or cleaning. So now a lot of photos are required. So for any new leases after July 1st this year, a landlord is required to take photos immediately upon moving in. So like right before you move in or maybe doing like a walkthrough at move-in, they have to take photos. And also they have to take photos when you move out and before they make any repairs or cleaning. And then subsequently after the repairs and cleaning are made, they have to take photos again showing the difference.
So no more of the, well, we had to clean the place because it was in need of cleaning and you'll just have to take our word for it. Now they have to document it and show before and after photos
Exactly.
to justify a security deposit deduction.
And how many cases or clients and phone calls do you get about security deposit disputes? Because I feel like it is a hot topic.
It is, and it's, I mean, prior to the mandatory documentation with photos, a very subjective topic. What is clean? Mm-hmm. And then to get into the kind of older nitty-gritty, what was reasonable wear and tear that a landlord can't deduct from a security deposit versus above and beyond normal wear and tear damage that the landlord can deduct from.
Right.
I mean, there's still going to be some subjectivity, but it is nice to show, oh, well, your before and after photos are identical.
Right.
Why am I losing money on this?
No, for sure. I don't think I've ever moved out of a unit and not paid a cleaning fee after I just hired someone to clean the unit. So it's very frustrating. I hope to see moving forward that the photos will prove like fruitful for a tenant and make it easier to dispute the deductions. I believe that if the landlord doesn't follow the law and comply with these updates, obviously you can push back on the deductions, ask for the photos, ask for the invoices, evidence. If they don't have any, then obviously I think the tenant would have a stronger argument that the deductions are not lawful.
Absolutely. And I would say, it's never documentation coming from attorneys. Mm-hmm. Documentation's never a bad thing. I mean, it's helpful to the landlords as well. They're having a small amount of extra work that they've got to do, but I mean, it's helpful for them to have even before it was required. it would have been a good idea. It would have been something I would recommend to any landlord before it was a mandatory thing for them to do, just so it takes the subjective element out of it. There is no need to have an argument, well, this was kind of dirty, and there was, there's smudges, and this, no, here it is, here it was, here it is afterwards.
Right.
This is why you're being charged whatever the cleaning costs were.
Exactly. And also language they added to the statute also discusses professional cleaning services and carpet cleaning services. I've read so many leases where even my lease, I don't know, might say it, but when I move out, I'm required to pay for professional carpet cleaning. Yep. And I think, obviously, if you've lived somewhere for years and years, it's probably warranted that, the carpet might be dirty beyond normal wear and tear. But, for example, I had a case recently where a client lived in this unit for 4 months, and the lease required her to pay for professional carpet cleaning. And obviously, she had not caused much damage at all to the carpet that would have warranted professional cleaning services. And so I had assisted her with pushing back on the clause in the lease as just being unlawful, obviously, and she should not be required to pay for these additional services if it's not needed.
And do you know if that was successful, or maybe that's still still
right.
pending?
Obviously, you make an argument, and she moved out, and she's happy in her new unit. And if the landlord chooses to pursue it, say, in small claims, we'll see. But obviously, I think with the updates made, and she had signed the lease and moved out after July 1st, so obviously these would apply to her. So obviously, she documented everything. She did a final walkthrough. She took photos, videos, so I think she has a very strong case if the landlord decides that he wants to pursue it.
Gotcha.
Yes.
Our favorite kinds of court cases are the ones that never get filed.
Yes,
much
exactly.
easier to deal with.
Also, it's obviously with the cost of filing a small claim and the time and effort for, I don't know, what are we talking, a few $100s when you don't have a strong case? Good luck. But did you have any other, questions, lingering questions or thoughts about updates to the security deposit law?
No, I'm informed. I hope I don't have to swap units or do anything else that's going to require a new security deposit, but it's good to know those protections are there.
Yeah, and obviously the same protections apply. The landlord has 21 days after you vacate to return the full deposit or minus allowable deductions. The same allowable deductions apply as far as repairs, damage, cleaning beyond normal wear and tear. Those are still all in place.
And past due rent, always fun.
Always past due rent, yes. All right, perfect. Let me jump to the next topic. So this is actually just a proposal, but I have been following it recently because I find it very interesting. Obviously, I think that it is, if it does pass, would provide a lot of more protections, more transparency as far as tenant rights go. So the proposal is both at the city and county level, and it's a residential rental price gouging, fee exploitation, and cost transparency ordinance. Also heard it called the junk fee ordinance, but pretty much, when you find a listing, sign a lease, you obviously agree to pay a monthly rent amount, but there could be additional charges tacked on, like parking fees, storage fees, pet rent. All of these things just make the monthly rent amount so much higher when we already live in a very expensive housing market.
Yeah, we do.
Yeah, no, for sure. And so it just, the Board of Supervisors at the county level on a 3-2 vote just approved it moving forward. And so in the next few months, expected to see a report back with a draft ordinance. But essentially, if it passes right now, this ordinance would cap add-on fees to no more than 5% of monthly rent. It would limit late fees to 2% and restrict or ban certain add-on charges. And again, these add-on charges are parking fees, pet rent, storage, pest control fees, community amenities, application and screening fees, and so much more. Also, I was skimming through just like charges to applicants and charges to tenants. And another thing that I found really interesting was that a tenant applying for a unit can bring their own tenant screening report with them.
Because I know those always come with a fee. It would definitely help to have one and be done with it as opposed to getting a new one at each place you end up applying to.
Yeah, and I know they've made changes in recent years about how you charge tenants. Like, you're not supposed to be collecting or accepting that fee if you've already found a reliable tenant who can move in.
Seems like common sense.
Yeah, of course. No, and those fees change annually as well. I think it's like somewhere in between, maybe around like $60 they can charge for just that application fee. But yeah, if you're applying for multiple units, I mean, it could be in the hundreds by the time you find a place to live. So I think this is really interesting. I will definitely keep an eye out on this proposal, this bill, and provide updates if it passes.
And you mentioned at the county level, which would be great. We don't need to specify, but you mentioned at the city level. Is it just City of San Diego or City of Chula Vista? Just City of San Diego for now?
Yeah, for now. So right now there are 2 ordinances they're kind of in the draft stage, but you can follow them at the city level and at the county level as well. And they're very similar. So pretty much the percentages and what a landlord can charge for in addition to monthly rent, very similar. Obviously, there's a lot of pushback from landlords, apartment associations, arguing that landlords should be able to charge these fees. Otherwise,
Yes, I'll just editorialize a little bit.
Yeah.
The landlords have already lost the battle if it's accepted terminology that these are junk fees.
Yeah. No,
the jig is up.
Yeah. No, it's a great nickname for it, junk fees.
So we're talking about an appeals case that is relatively recent that dealt with.
It was June. It's
June
actually
of
my dad's
2025.
birthday, June 26th, of this year. So it was a Court of Appeals case, and it pretty much reaffirmed what needs to be in a 3-day notice and also added new requirements for a 3-day notice. And essentially, this 3-day notice was very butchered.
In the case,
yeah. So in the case, it was a 3-day pay or quit notice. It didn't clearly say when the 3-day deadline started and ended. It didn't warn that the landlord would be able to take back the property if rent was not paid. And it didn't give a proper payment location. So obviously I can imagine the tenant was very confused when he got this 3-day notice. And so the ruling found that the notice was defective, obviously, because it failed to state when the 3-day period began and ended. So it clearly needs to say that compliance must be made in 3 days, excluding Saturdays, Sundays, and court holidays. It clearly needs to warn that the landlord would be able to repossess the property, obviously only after going through the court process to evict. And it has to state a valid address where payment can be made. So moving forward, some new requirements that must be in a 3-day notice to pay or quit, which arguably might need to be in other 3-day notices as well, because this one's pay or quit, but there's other 3-day notices probably, like for a lease violation, let's say.
The less common, but still, those are important.
So it needs to have an expiration date. So say it starts on this day, ends on this day, but say it goes over a weekend or a court holiday, it has to take all of those dates into account and then actually clearly state a date that the notice expires, so it's not left up to interpretation. I think personally, I see a lot of 30 or 60-day notices, and I'm pulling up a date calculator on the computer because I don't know what day does this actually expire. Obviously, day one starts the following day after you get the notice, but then you're kind of playing a guessing game. oh, is there 30 months this month, 31? Is it a leap year? I don't know. So it has to clearly state what date the notice expires.
I'll throw in there too. Court holidays. There are some funky court holidays
Yeah.
that a lot of regular working folks or folks going to school do not get off, wouldn't necessarily know, oh, that actually is a court holiday. That does not count.
Right. Yeah, and that can be important, obviously, if you're getting like a notice for non-payment and you need to find maybe help financially, or if you're working or you're waiting on a paycheck, I don't know. But obviously every day counts with a 3-day notice. Also a new requirement with the notice is it has to be served and dated. So when the, say, landlord, owner, property manager signs the notice, they must date it the same day that it's served. And so I think that is just to clear up some confusion. When did I receive this notice? Because they could have dated it like a week prior, and then you might have found it and you're like, I don't know how long this has been sitting on my door or in my mailbox. So those dates now have to align, which I think hopefully will, again, clear up confusion moving forward.
So the grand total, all the new requirements, just as a result of this one appellate case are...
Yeah, I would say there was 2 new requirements, and like one, it reinforced just one thing that's already been in notices, right? So the thing that's been reinforced is that it must clearly state that Saturdays, Sundays, and court holidays are exempt. And then as far as new requirements go, the notice must be signed and dated and served on the same day.
What I remember from what you've said was so landlord's got or the notice has to specify what days are excluded from the
so it kind
count.
It reaffirmed that a notice has to clearly state that Saturdays, Sundays, and court holidays are exempt.
It's got to give a specific date rather than just say you have 3 days. It's got to say you have 3 days, which in this case is going to be, whatever, February 28th.
Right. They have to now calculate the date. I guess it can't be left up to question, right? What day does this expire?
That's got to be written on the notice.
Yes.
And it's got to be dated and signed and delivered the same day.
Correct. Yeah. So those are...
I count that as 3.
I'd count that as 3 things. Yeah. And I feel like sometimes, I don't know, when you have a client, they might be confused when they got the notice, when it expires. Also, I just feel like sometimes they're not even signed and dated either. And so I think these are just... having these new requirements helps a client by pointing out that this notice is defective and you have to reissue a new notice. And ultimately the goal is to buy them more time to correct any alleged violation.
Absolutely. I mean, that would be our goal, I would say. The goal of this case is just to, honestly, it seems like to emphasize the common sense element. You would think this was already mandatory. It is now. Right.
No, it's helpful to have laws or cases to point to.
For us, yes, absolutely.
Yes, for sure. Kind of eliminate that gray area.
So, yep, a deadline shouldn't be nebulous.
Correct. All right. Well, thanks for joining me today. It's been great to catch up and talk about housing law.
Always good to get updates on the law. Closing comments.
Yes, closing comments. Obviously, I think that housing law is always ever changing, and so it's important to stay updated on, what's going on, to voice your opinion, and as a tenant advocate to help your clients, obviously defend their tenant rights.
Always good to hear.
Well, I think if you need legal help, housing or beyond, that you can contact Elder Law and Advocacy at 858-565-1392 to speak with our intake.